So the state of California had that assault weapons ban essentially ruled against by a federal judge, and how is that going to impact Illinois? Well, I talked with Alan Gottlieb. He is the founder of the Second Amendment Foundation, who's also a plaintiff in the Illinois case, and he says that the challenge out of California is good news for Illinois' case, where, of course, California judge in the Southern District said that the gun ban in that state is unconstitutional, but put a stay, self-imposed stay on that ruling for 10 days while the state of California appealed, and they did appeal. But what is happening now in the Northern District of Illinois and the Southern District of Illinois with the cases pending in the Seventh Circuit Court of Appeals, you've got plaintiffs who have filed a supplemental authority to say, hey, Seventh Circuit Court of Appeals, look over at the Southern District of Illinois and what's happened there with Judge Benitez saying that the gun ban is unconstitutional, issuing a permanent injunction, not a preliminary injunction, a permanent injunction. And this is a case out of California that started way back in 2019. And one of the plaintiffs in that case is the Second Amendment Foundation, and I connected with Alan Gottlieb. He is from the Second Amendment Foundation, the founder of the Second Amendment Foundation, and he shared with me his reaction on Friday.
Well, of course, we won a major decision knocking down California's so-called assault weapon ban as being unconstitutional. Obviously, the state has already filed notice that they're going to appeal, and it'll go up to the appeals court. What's interesting is that this case has already been there once before. We won this with the same judge a few years ago. It went up to the appeals court, and it then went all the way up to the en banc appeals court, which then, after the Bruin ruling, where the Supreme Court, said that you have to go by the text of the Second Amendment and the history, not by any, social science or, balancing act test, the court remanded it back down to the court to review it in light of the Supreme Court ruling and came up with a stronger ruling in our favor. And now it's going to go back up through the process. Eventually, it's going to go to the U.S. Supreme Court. It may not be the first assault and ban case to actually get there. The Second Amendment Foundation has previous cases filed in Illinois and Maryland that might get there first. But the Supreme Court is definitely going to be hearing this case, and eventually California citizens will get relief and be able to own semi-automatic firearms that the state likes to call assault weapons. The judge issued a preliminary injunction but stayed it for 10 days to allow the state of California to file their appeal. My guess is the law will stay in effect until it runs through the appeal process.
So again, Alan Gottlieb, the founder of the Second Amendment Foundation, reacting to Thursday's ruling out of California and how exactly that's going to impact Illinois. And in particular, you've got the plaintiffs in Illinois, the Second Amendment Foundation being one of several plaintiffs groups, ranging from the Illinois State Rifle Association to the Federal Firearms Licensees of Illinois. So obviously you've got the plaintiffs saying, hey, Seventh Circuit Court of Appeals, look at what happened over in California. And Gottlieb saying that what happened in California very much is going to strengthen Illinois' challenge of the gun and magazine ban.
Well, of course, the Second Amendment Foundation is one of those plaintiffs, and we will be surely filing a supplemental authority briefing with the court there. And it will affect it. We've already won at a lower court level in Illinois on this issue already, so it's going to affect the appeal. But again, if it's illegal and unconstitutional in California, it's also illegal and unconstitutional in other states like Illinois as well. This strengthens our Illinois challenge.
So, again, a supplemental authority, if I said appropriation, I'm just thinking about veto session coming up and if there's going to be possibly more spending for state tax dollars. But a supplemental authority is what is filed in the Seventh Circuit Court of Appeals, and that has been filed. And one of the things they point out is several of Benitez's quotes in his shooting down of California's gun ban, and one of them was this question about in common use and what is in common use. And, the states, and even in Illinois, they have said that, well, in common use means being used actively in self-defense, and they say that semi-automatic rifles like AR-15s are not actively used in self-defense. But Judge Benitez said something to the effect of that using a firearm that's underneath the bed is still in use for self-defense even when the night is quiet. And that's an interesting perspective. So, again, the Seventh Circuit Court of Appeals being asked, and they did indeed, plaintiffs filed that supplemental authority on Friday to have the Seventh Circuit Court of Appeals review the Southern District of California and Judge Benitez's ruling against that state's gun ban. But there are other gun bans in different states, not just in Illinois, not just in California. More from Alan Gottlieb.
Yeah, there are 8 or 9 states that have these kinds of laws on the books right now. California, Oregon, Washington, Illinois, Maryland, New York, New Jersey, Massachusetts. And so it's going to impact us. It's going to take time. And like I tell gun owners and gun rights supporters, you got to be a little patient. The court system just doesn't work that quickly overnight. Eventually, we are going to win this case. It's going to go to the U.S. Supreme Court, and the so-called open bans of commonly owned firearms that are not dangerous and unusual. Those laws are going to get struck down, and people are going to be able to continue to own those firearms.
And again, some of the other arguments are that AR-15s, for instance, are dangerous and unusual, but they're not necessarily unusual considered in common use. So we'll see how all this plays out. But that's just, one set of cases here, right? And you've got another instance down in the Southern District of Illinois where we're still waiting on some kind of ruling on the vagueness challenge. Because what's happening in the Seventh Circuit Court of Appeals is about the Second Amendment, not about vagueness, which Attorney Thomas Magg has that vagueness challenge pending in the Southern District of Illinois. So we'll be watching what happens there. But you've got, after California's ruling, California Governor Gavin Newsom essentially saying that the judge there is a partisan and that he's extreme and that there needs to be a constitutional amendment to change the U.S. Constitution to curb what kinds of firearms individuals can keep and bear that shall not be infringed. And I asked Gottlieb to react to that notion that those who support gun rights are extremists. And here's his response to California Governor Gavin Newsom, but also Governor J.B. Pritzker here in Illinois, who's made similar types of statements.
Well, these judges aren't radical. The politicians like Gavin Newsom and Pritzker they're the radicals. And the proof of it is they want to pass a new amendment to the Constitution to eradicate the Second Amendment and take away people's gun rights. That's what's is dangerous and unusual and radical.
So Alan Gottlieb, will definitely be talking with him again in the near future. Appreciate him connecting as he jet sets all across the country, getting these cases in order, at least from the Second Amendment Foundation's perspective. But that's not the only case. Locally, also, our neighbors to the west, Missouri, you have this story out of the Washington Examiner saying that the Supreme Court, the U.S. Supreme Court, on Friday left a Missouri law on hold that blocks police from enforcing federal gun laws in Missouri, rejecting an emergency appeal. This is kind of interesting. I'm curious how this could possibly impact, say, sanctuary counties in Illinois. I'm not talking about the migration stuff. We'll talk about the non-citizen migrants coming up in another segment here. I'm talking about gun sanctuary counties, because a lot of counties, dozens of counties in Illinois, have declared themselves gun sanctuary counties, where they say that gun laws won't be enforced in their county. Well, how's that going to play out? Well, this Missouri case, which essentially says, in question, the law, it's called the Second Amendment Preservation Act, and it was ruled unconstitutional by a district judge. It essentially says that you can fine a police officer $50,000 if they knowingly enforce federal gun laws that don't align with the state's own restrictions in Missouri. So again, a judge struck that down, and then you had the appeal play through and an emergency appeal all the way to the U.S. Supreme Court. Again, this is from a Missouri law, the Second Amendment Preservation Act, the U.S. Supreme Court stepping in and keeping a hold on that Missouri law. So that's yet another Second Amendment type of case that we will definitely be watching, because our neighbors to the west in Missouri dealing with that issue. So a lot of moving pieces when it comes to litigation against gun laws, and we'll obviously be watching all of that and more. But we've got plenty more to get to, all right? It's right here with Bishop on Air. Follow me anywhere. Just search Bishop on Air on Facebook, on Twitter, on X, formerly known as Twitter. Said that twice. Either way, make it happen, all right? Like, subscribe, hit the notification bell, and stay up to date with what's going on here in Illinois and beyond.